Good morning. Thank you, Judge Donald. Thank you, Congresswoman. I ran into Judge Donald at a American Constitution Society event a few weeks ago, and she asked me if I could speak here and do my thing. Of course, because she's Judge Donald and incredibly charming, and also Judge Donald, I said yes right away without thinking what it is that she thought my thing was. And as I looked at the program and learned that it was about the 14th Amendment, I realized that's not really my thing. I've talked extensively about the history of the Civil Rights Movement, but not necessarily about the 14th Amendment. And then when I saw that I was being advertised as a Harvard law professor, I realized that I had big shoes to fill, right? So I was following the tradition of Larry Tribe and Felix Frankfurter and other Harvard law professors, and I had explained that I am a lecturer in law at Harvard. I fly up there on Sunday. I teach a Civil Rights Frontiers class on Monday morning. Then I fly back to my day job. And so it's really within that context that I want to talk about the 14th Amendment. I think when we talk about the history of the 14th Amendment, I do apologize here because we had it all set up earlier. I'm not sure if we can do this again. Okay, when we... Oh. Where's my... Excuse me, folks. We had this set up. Let me... I'm gonna have to go over here. All right, I'm gonna go without my notes. Ha ha ha. Be careful, Lopez without his notes. Okay, let's let this come up. We're gonna do this without my notes. All right, so everybody knows who this is, right? This is Thomas Jefferson, author of the Declaration of Independence. Everybody knows who this is. James Madison, one of the primary architects of the United States Constitution, author of the Federalist Papers. Everybody knows who this is. Alexander Hamilton, one of the other authors of the Federalist Papers, right? So we know them. You guys know this guy? John Bingham. John Bingham, in many ways, has been as influential as the other three in the shaping of this country, the shaping of our ideas of federalism, the shaping of our ideas of rights. Yet people don't really know him. He was a congressman from Ohio, and he was the one who crafted Section 1 of the 14th Amendment. And he did this in the context of incredible violence after the Civil War. Incredible violence after the Civil War. Abraham Lincoln had been assassinated. Andrew Johnson, who was a bigot by any measure, ascended to the presidency. There were efforts to pass legislation that would grant African American men the full protections of the Constitution and voting rights, and he vetoed that. And even though Congress was able to override the veto, there was a recognition that they did not want to leave the rights of the recently freed African Americans to the political whims of Congress. And so there was a push for constitutional amendment, and John Bingham crafted this language. You needed the amendment to be ratified by 2/3 of the states. The first go-around, the 10 states of the Confederacy, all except Tennessee, voted against it. There was a second push, and with the military governments in those states and making a condition of readmission the passage of the 14th Amendment, the 14th Amendment was passed 150 years ago. And it's been tremendously influential in shaping our understanding of our rights and responsibilities as citizens. But it's been a very, very, very rough road. It's been tremendously rough. And I wanted to put together a list of the best 14th Amendment cases and the worst 14th Amendment cases. And frankly, there were more bad ones than good ones, in my view, when you deal with civil society. Now, I know this is the criminal justice section, and I know the 14th Amendment has been tremendously influential, and you had cases like Powell versus Alabama and Gideon versus Wainwright, and those cases have been fundamentally transformative of our understanding of the criminal justice section. I'm not going to talk about those cases, but I do want to talk about some of the bad ones, and I want to talk about some of the good ones. And I want you to think about what the world would have looked like in the spirit of the book, The Underground, if these cases had come out different. How would our world have changed if these cases had come out different? Let's start with the bad ones. Now, in law school, they always teach this case, the slaughterhouse cases, and that was always a real confusing one because that was one of the first 14th Amendment cases, and it dealt with a citywide monopoly in Louisiana, okay? And there was a challenge to it under the 14th Amendment by white butchers, and the Supreme Court used that as an opportunity to eviscerate the Privileges and Immunities Clause of the 14th Amendment. It eviscerated, and we all learn about that. But that case is always very confusing, right? Not in terms of the impact, but in terms of the facts. But one that's often neglected is this one, United States versus Cruikshank. This was a case that arose out of the Koufax Massacre in Louisiana. After the Civil War, African Americans held a tremendous amount of potential political power in the South, particularly in Louisiana, Alabama, and Mississippi. And there was enormous resistance to the exercise of that political power. And by enormous resistance, I mean terrorism and violence, right? We know that. We know the history of terrorism in our country. And the Colfax Massacre was a battle between the white Democrats and the African American Republicans, and it was a political battle. And it resulted in the murder, the massacre of 250 African Americans at least. No one really knows. In 1870, Congress passed the Ku Klux Klan Act to address violence and terror in the South, and there were prosecutions of the Koufax Massacre, not that many, but a few. And one of those individuals prosecuted was Joe Cruikshank, and his case made it to the Supreme Court of the United States of America. The United States of America. And if you read this decision, you're not going to read about the bloody background or the bloody facts at all. Very unclear what the context of this case was when you read it. That it grew out of the political violence of the era. But what was clear is that the convictions were overturned under the 14th Amendment. And what you see in this decision are three strands that would haunt this country. You saw the idea that the 14th Amendment could not reach the conduct of private individuals who were depriving others of others of liberty and constitutional rights. It did not reach the private conduct. It needed the state action. You get the idea that in order to make a constitutional claim, you needed to show intent. You needed to show racial intent. And you get this idea that there are different rights. There are national rights and there are state rights. And the rights of the state are reserved to the states, and the federal government cannot go in and try to enforce state rights. A bad decision that haunted us. And what happened afterwards or concurrently is that the prosecutions of political violence, of racial violence, stopped. The political configuration switched. The African Americans were disenfranchised effectively through terror and other chicanery for almost 100 years. We all know about the Civil Rights Act of 1964 and the public accommodation laws and Rosa Parks. We know about that, right? But do you know about the Civil Rights Act of 1875? It was a public accommodations law. It reached the exclusion based on race from public accommodations. That was the purpose of the law. 1875. 80 years, 90 years before the passage of the Civil Rights Law. There were several cases that were brought to the Supreme Court involving the denial of public accommodations, the denial of orchestra seats to African Americans, to the ability to sit in certain sections of the train. 4 cases went to the Supreme Court, the civil rights cases, and the Supreme Court gutted the act. Gutted the act. This does not deal with state action, the Supreme Court said. There's no state action. 14th Amendment does not allow the federal government to reach private conduct. The public accommodations law is unconstitutional. And then, with the cherry on top, this is 1875, folks. It's not 2016. When a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of the stage, there must be some stage in the progress of his elevation where he takes the rank of mere citizen and ceases to be the special favorite of the laws, and when his rights as a citizen or a man are to be protected in the ordinary mode by which other men's rights are protected. 1875, on the hills, in the midst of incredible violence, racial violence. Justice Joseph Bradley wrote those words. And so what you do is you lost federal protection against political violence, because that's a state matter. Let the states correct political violence. They gutted public accommodation laws, and then we know this one, Plessy V Ferguson, Homer Plessy, 1/16 African American, but there was a one-drop rule. The one-drop rule, if you had 1 drop of African American blood, you're African American and subject to the Jim Crow laws of the state. This was a test case. So for all you civil rights advocates, this was the Comité des Citoyens. They pushed this case. They wanted to challenge the whole idea of segregation in the South, and they lost 7-1. We all know about that. Judge A. Leon Higginbotham, who was a professor of mine at Harvard, used to talk about this case, and he used to always point out to the little snotty Harvard students that the Supreme Court that handed down this decision was comprised of 3 Harvard Law graduates, 3 from Yale and 1 from Columbia, and the dissenter Justice Harlan went to Transylvania State. The lifeblood of the law is values, he would tell us, not technical prowess, values. Buck v. Bell. Oliver Wendell Holmes is generally considered one of the finest justices. He's a beautiful writer. It's not his finest moment. This is a Virginia Eugenics Law passed in 1920. State of Virginia wanted to test whether they could sterilize what they termed imbeciles. They would give you a test and they would decide whether you were an imbecile or a moron. Those were the words that they used. And they wanted, consistent with the fashionable scientific theory of eugenics of the time, they wanted to sterilize imbeciles, sterilized imbeciles. Carrie Buck was not an imbecile. She had a bad life. She lived in a foster home. She was raped. And instead of her foster parents stepping up to the plate and dealing with that, they placed her in an institution for the enfeebled. And they sterilized her, and they wanted to test the law, so they gave her a lawyer. The state of Virginia gives her a lawyer. Let's test the law. The lawyer basically threw it at every step of the way, and it resulted in an 8-1 decision. It is better for the world if instead of waiting to execute degenerate offspring for a crime or to let them starve for the imbecility, society can prevent those who are manifestly unfit from continuing their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. 3 generations of imbeciles are enough, reflecting the fashionable idea of eugenics that, by the way, found a fertile home at Harvard University and was inspiration, as pointed out during the Nuremberg hearings, for the Nazis. American eugenics. American eugenics. It was also inspiration for a race-based immigration system. And you ask, what of African Americans during this period? Well, African Americans were treated in Virginia as even less than people. And Virginia passed a racial purity law at the same time it passed the sterilization law. We're going to talk about the racial purity law when we get to the good cases. Not a fine moment. Lochner versus New York. We read this one in law school. Industrial Revolution, industrial death, child labor. Many states went in to try to regulate the labor conditions, New York tried to do it in the bakeries, saying that you couldn't work more than 10 hours a day. Supreme Court said, it's a violation of the Equal Protection Clause. You can't do that because the Constitution creates a liberty to contract. A liberty of contract, that's what the Supreme Court said. Protected by the Constitution, and the state of New York is abrogating that right to have liberty to contract by passing this legislation. The laissez-faire mentality. And curiously, Justice Holmes points that out. He says, look, the Constitution doesn't enshrine, in dissent, doesn't enshrine any economic theory. It doesn't enact Herbert Spencer's social statics. It may enact eugenics, but not Herbert Spencer's social statics, right? And I just do this to redeem Oliver Wendell Holmes, because this is a beautiful dissent, and this defined the landscape of labor regulation until the famous switch in time that saved 9. Remember, Franklin Roosevelt was going to start packing the Supreme Court because all of his New Deal legislation was being struck down, and finally the Supreme Court slowly reversed course on this sort of Lochnerian idea that there's a constitutional right to the liberty of contract. This one people don't talk about very much. When we get to Brown v. Board of Education, you're going to hear how eloquent the Supreme Court is about how education is fundamental to citizenship. Education is fundamental to opportunity. State of Texas, like many states, would match the finance of the local school districts. The poor districts, of course, didn't raise nearly as much money from the tax base as the rich districts. So there's incredible disparities, right? Incredible disparities in school financing, not unconstitutional according to the Supreme Court. Education is not a right under the Constitution. Class is not a protected basis. When you match this one with a later case called Milliken v. Bradley, which said that the suburbs didn't have an obligation to desegregate, what you do is you get the effective overruling of Brown v. Board of Education. And you still have these disparities today. We all know it. You still have these disparities. Past that one. Bowers v. Hardwick. In America, this case happened. Outside of a gay club in Georgia, a cop notices that one of the employees of this club is throwing an empty bottle of liquor in the garbage can, cites him for public consumption of alcohol, issues a warrant for his arrest. No, issues a warrant for him to appear. He doesn't appear. Cops show up at his house in the United States of America, knock on the door, there's somebody there. I don't know where he is, but you're free to come in and check the house. The cops find him engaged in oral sex with another man. Arrest him under the anti-sodomy laws of the state of Georgia. It's a 20-year sentence. 20-year sentence. Case goes up to the Supreme Court. Supreme Court upholds the sodomy laws of the state of Georgia, 5-4. Upholds them based on Judeo-Christian tradition. Says that this is not protected by the Constitution. Famously, the fifth vote was Justice Lewis Powell, who really tried to figure this out. And he goes, I've never had a gay law clerk. And we know this story from his gay law clerk, who apparently pushed back but didn't come out on this question, 5-4. And he says it was a mistake. 17 years later, this was overturned by the Supreme Court in Lawrence v. Texas. Bush v. Gore. Remember that? 2000. Mayhem, political mayhem, goes to the Supreme Court. The question has to do with how you recount the vote in 4 counties, right, in Florida. And all the counties had different standards. And so the Supreme Court says, look, this is a violation of the Equal Protection Act. There's no way to come up with a standardized way to recount the votes in those 4 counties. And that means that some counties are going to have more power, some of the voters are going to have more weight to their vote than others. It's a violation of the Equal Protection Clause. And then when it got to the issue of remedy, of whether to send it back for further recount, a statewide recount, the Supreme Court put a stop to it. It says no recount. Now, conservative and liberal scholars are very critical of the 14th Amendment aspect of this. And even the Supreme Court knew that it would be limited to the circumstances. They try to make it very clear that this would be non-precedential. It's worthwhile to point out that Justice Scalia, Rehnquist, and Thomas almost uniformly would refuse statistically to find equal protection violations in cases involving African Americans. And in the affirmative action cases, they would uniformly apply the Equal Protection Clause in favor of the white plaintiffs. Okay, it's not all bad news. Stouter versus West Virginia. This is back in the day. Supreme Court said that you cannot exclude African Americans from a jury, that was a right that was protected in the Constitution. Said that you could exclude women, by the way, in the decision. So I almost took this one out this morning, right? I almost took this one out this morning. Brown v. Board of Education, we all know that case. It finally reversed Plessy v. Ferguson, 1954. Took about 60 years to do it. 60 years of the color line, 60 years of Jim Crow, 60 years of racial violence, 60 years of segregation, 60 years of people not knowing each other in a community and an egalitarian basis. What could have been, folks? Baker v. Carr. Supreme Court was jumping into the whole idea. In some states, you had districts in the rural areas that had very few people, legislative districts, and then the urban areas in Tennessee, where it was predominantly or more disproportionately African Americans, they had the same representation for more people. Reynolds v. Sim took this one step later and said, the basic principle is one person, one vote. Very important cases, because we take all of this for granted. But up until 1964, 1965 with the Voting Rights Act, the whole idea of having the franchise and having it weigh as much as it did for other people was not the norm, right? And we understand this now, and we understand retrospectively the civil rights implications for this. Loving versus Virginia, the racial purity laws that were passed at the same time as the sterilization laws prohibited the marriage between the races. This is a subject of a wonderful movie. This was struck down by the Supreme Court. Great decision. I'll jump on that one. And then this one we were talking about earlier. There's certain events in America, certain events like 9/11, for certain people, the assassination of John Kennedy, where you remember what you were doing on that day. And Obergefell has become one of those. The Obergefell decision, people remember what they were doing when the Supreme Court came out and said that under the Constitution, you can marry who you love. A major decision, 5-4 decision, Justice Kennedy. Now, I just want to finish up by just asking this question. Because one thing that Judge Higginbotham used to always talk about is, don't get caught up in the idea that these were the fashions of the time. Harlan dissented, right? You have dissenters in all these cases. You have moral choices in all these cases. You have Oliver Wendell Holmes with that horrific decision. You have Felix Frankfurter and Korematsu writing with the majority. You have justices who are viewed as bastions of progressivism and intellect, who are often making these bad moral choices. And so it's always worthwhile to think of what we would have done in those circumstances, with a sense of humility, but also with the sense that the lifeblood of the law has to do with values and has to do with morals. Thank you.